If your client doesn't meet the credit counseling requirements, you're going to hear either from the court directly or you're going to hear from me. And depending on how far off the 180 days you are, it depends on which one you will hear from. If your client does not get bankruptcy credit counseling, you're going to get a motion to dismiss. If they get their credit counseling more than 180 days before they file bankruptcy, you're going to end up with the case being dismissed. And if they get the counseling after bankruptcy, you're going to end up with the case being dismissed. And if they are a representative party and their case gets dismissed under credit counseling, we are going to expect counsel to pay the refiling fee, because we expected you to know that the case should not have been filed in the first place. And I think the courts have universally backed us in those requests, and I would expect them to continue to do so unless there's some absolutely extraordinary circumstances that led you to file the case even though the certificate was out of date or not obtained. You're going to see us in the 707B world. If you haven't already heard from Todd Vandenberg, you probably will if you file cases long enough. Todd Vandenberg is a bankruptcy analyst out of Des Moines. Craig Blumen would have been his counterpart here originally. Todd is a bankruptcy analyst, which is my version of an accountant. Todd is solely responsible for reviewing filings that come through our system for 707B issues. And if he thinks there's an issue, he's going to send you an email and he's going to ask for information. And usually we're going to be asking you about debt information or for verification of expenses, items that are put on either the B-22 or Schedule J. The easiest thing in the world is to cooperate with Todd, because about 70% of the time, Todd gets enough information to determine that either the presumption doesn't arise or that there's not an appropriate reason to bring a B3 motion, and we all go on down the road. If he thinks that a motion is warranted, it's going to end up in my box, and we're going to get the motion on file, and we'll go from there. If he can't get information, then I'm going to have to go to Judge Nail, and I'm going to have to ask for the information to be produced in another format. And the experience with Mr. Gehring has been that the court really prefers it if we can all get along and share information back and forth so that we can make these determinations without any type of formal discovery process. But if we have to go there, we will. Easier things, and Todd is the nicest guy in the world. He's easy to communicate with, easy to talk to. Also, if you have questions regarding 707B, issues related to filing, issues related to the means test, give Marcy a call. She will give you Todd's number, and you can give Todd a call and talk it through. If it's a legal issue and he needs help, he'll talk to me. But more often than not, I go to him, he doesn't come to me. So if you've got issues in that area, give Todd a call and he'll help you out. 727 is an area that's big for us. We rely on our trustees to look at cases and to refer to us cases that just don't seem right. And we have gotten a number of those referrals over the past 6 months or so. About half of those I've ended up acting on. And if something doesn't look right, you may not hear from me prior to the complaint being filed. I've gotten a lot of information from our trustees. They've had 341 meetings. They've often obtained documentation. They've looked at the schedules. They are consummate professionals. If they tell me there is something wrong with this case and here's what it is, and I agree with their assessment, I'm not likely to write you a note ahead of time saying, hey, we have concerns about your debtor's failure to disclose this asset that the trustee has now discovered. I'm simply going to file a complaint saying your debtor failed to disclose this asset that the trustee has now discovered. And we'll discuss the rest of those niceties down the road. I'm much more likely to put the complaint on file with ever talking to you first, because that's all been taken care of by the trustee. By the time those referrals come to us, we've got a litany of discussions back and forth between the trustee's office and your office that indicate, at least to me, that this is an undisclosed asset or that there is a basis for me bringing these complaints. And we have filed a number of them. With any luck, I'll get enough budget to actually try some of them if it comes to that, and try to go back to city for at least a couple. So you are going to see us in the 727 world. We push on the trustees awful hard to make sure that those cases get referred to us, because being the watchdog of the system, I don't like the term, but it is incumbent upon me to try and make sure that everybody plays by the rules, and debtors have a very specific set of rules under Section 521 and Section 727, and when they aren't playing by those rules, it's incumbent upon me to ask Judge Nail to intervene and to do something about it. So you will see us there. You'll see this in the Chapter 11 world. Right now we have one Chapter 11, and I've been way too involved in that case for my own liking. We now have creditors up and running, and hopefully they can take care of it on their own from now on. But in 327 through 28, 329, 330, applications to employ and fee applications you're going to see from the U.S. trustee. We do look at those applications to employ. We will, if appropriate, file comment or objection to those. And we look at all the fee apps coming through, and again, where appropriate, we will file a comment or an objection to those fee applications. I will almost always try and talk to you first. With the exception of 727, you will almost always hear from me before I do anything formal in a case. I will always, if it's a Chapter 11 setting and I've got trouble with the fee application, I will give you a call, I'll send you an email, and say, here's my concern. We'll either work it out or we won't. And if we can't, then ultimately I will let Judge Nail decide it. That is an area that you will see us actively involved in. If we get beyond the one Chapter 11 case that we have now, you will see me involved in disclosure statements and plans. I have an independent obligation to review those disclosure statements for adequate information, plans for compliance with Section 1129. And I try, and I've got a checklist, and I sort of know what I'm doing in that area, and I try and go through all the plans and make sure that if I have concerns, that I raise those with you, and if we can't work it out, that I raise those with the court. We have an obligation under the code, as does the court, that if we stumble across anything that we believe is a criminal matter, we are to refer that matter to the appropriate law enforcement and prosecutorial agency. 90% of the time, that means the U.S. Attorney and the FBI. My obligation goes beyond the court statute. The court statute is to make referral. Mine is to cooperate and assist in the prosecution and investigation of the case as requested by the agency. So we are actively involved, at least in South Dakota, not so much in the investigation, which we do a lot of in the Southern District of Iowa, but in assisting the U.S. Attorney in making determinations as to whether to prosecute, and if prosecution becomes necessary, providing expert advice and testimony to the U.S. Attorney's Office related to bankruptcy crimes. I haven't seen a lot of those. All the referrals that we have on file were made by Mr. Gehring before his retirement, and at this point, I don't actually know the status of some of those cases because they're pending versus while some civil matters are resolved. But that is an area that you will find that we are actively involved in. Lastly, you'll find that we are actively involved in a creditor abuse initiative set by the U.S. Trustee's Executive Office. For those of you who do creditor work, that means please know the rules for filing proofs of claim. In particular, know what 3002, 3002.1, and 3003 say, because I'm obligated to review all the proofs of claim, especially those secured by a first mortgage in the debtor's residence, and to make sure that those claims comply with those rules. If they don't, you will hear from someone in our office, probably an attorney out of Minneapolis initially, and then ultimately an objection will have to be filed. Some general practice tips, and I will try not to go long and keep everything on track here. Understand that when we get into areas like criminal referrals, bankruptcy has a unique set of rules, particularly in relation to the attorney-client privilege. There are some very clear limitations on the attorney-client privilege in a bankruptcy setting. Most notably, anything that the client told you that was to be included in the schedules and statement of financial affairs is not confidential. Therefore, that information, worksheets, notes, conversations you had with your client about what those schedules say and what information should be in them, is not necessarily privileged, and in fact, generally is considered not to be privileged. Likewise, when I bring a 727 action for the asset that has been concealed, and the client does what they normally do, which is say, well, I told my attorney all about this. Anything they didn't tell you is not privileged because there was no communication. And credit where credit is due, most of what I know about this came from an article from the South Dakota Law Review, which I believe was written by someone who was working for the clerk's office at the time, who may now be on the bench. I believe Judge Nail and Craig Gomer, who's a U.S. attorney, wrote a very good article. It's a little dated now, but take a look at that article and go from there, because it gives you the rules on what attorney-client privilege issues are in bankruptcy, and there are definitely some issues there, and I will push them because when somebody says advice of counsel as their defense, I believe I have the right to obtain information that might be attorney-client privileged in a non-bankruptcy setting, and I will subpoena that information with the approval of the Department of Justice and move down the road with that. I can't stress this enough, and I stress this because of how difficult it is for me. I come from the Southern District of Iowa where we have no local rules. Now, I say that tongue-in-cheek because while the judge will say we have no local rules, and she's correct, there are no written document entitled local rules. There are the Federal Rules of Bankruptcy Procedure as interpreted by the court, and I will be darned if I don't believe that she interprets some of those differently than the way I read them, which seems to me like a local rule, but they're not written down. You guys have local rules. You have a very complete and complex set of local rules I would be familiar with. I say that because I panic and look at them about 3 times a week because I'm not used to having local rules, and I always forget that I should go look at this set, and usually Marcy catches me before I do anything totally stupid. But know your local rules and your service rules. And there's a wonderful document, I think they call it the cheat sheet. There's a wonderful document that the court has produced that allows you to make sure you've got your service right in the bankruptcy setting. And that is essential in this world. Let's see. Remember especially if you're doing debtor's counsel work, remember the real party and interest issues. If you've got a client who comes to you who has state court litigation that might be an asset of the bankruptcy case, remember that when you file that case, they are no longer potentially the plaintiff of that action, and that most likely that asset passed to the trustee, and that the trustee is the proper person and the proper party in interest to be bringing that case. I mention this because I'm pretty sure defense counsel, the insurance defense counsel are aware of this. They are in Iowa because I talked to them yesterday. So it is going to be an issue for your client. And again, if the first time the trustees heard about the personal injury action is when the defense counsel calls and says, hey, how come you're not the real party in interest in this case? That probably means that asset was concealed. So the trustee's going to take over the case. They're going to arrange the settlement of litigation, and then they're going to refer the case to me for 727. Your client's going to lose the discharge. So be sure when you're talking to your clients, you explain to them that there are issues in the bankruptcy setting, and that they have any of these causes of action, to make sure that they tell you about them and that they get properly scheduled and disclosed, because it causes problems on both the state court side and the bankruptcy process. Likewise, if you are representing someone in a personal injury action and they file bankruptcy, be prepared for the fact that they are no longer your client. Your client becomes the bankruptcy estate represented by the trustee. And there's some very specific rules that go into play then, like you must be employed by the bankruptcy court and your fee must be approved by the bankruptcy court in order to go forward. Trustees are real happy to retain pre-bankruptcy counsel as long as pre-bankruptcy counsel agrees to play by the bankruptcy rules and understand that the trustee, not the former debtor, is the new person that they should be talking to about settlement and other issues related to the case. And we've had this problem. We've had plaintiffs' attorneys who have had the bankruptcy filing, they've been employed by the court, and then they have continued to represent the debtor, and they've actually settled the case on behalf of the debtor, not on behalf of the trustee. That's an unfortunate circumstance where they lose all of their fees and they get bar referral. So that's something you want to make sure you avoid. If there's a bankruptcy in play, make sure that you're on the same side as the trustee if you're representing the debtor out there. Last, and I'll keep it short here, there is a new seminal decision on bankruptcy court jurisdiction. And I could just tell you what the holding is, but that's no fun because this case has enough story behind it that you almost have to tell a story to make it fun. So bear with me for just a second, this will all make sense. This really is the story of the American dream gone wrong. In the American dream, Vicki Lynn Hogan drops out of high school, age 17, goes to work as a waitress, marries a 16-year-old fry cook, and has family. Not maybe the best decision she's ever made. Divorces the fry cook, sort of. They separate, doesn't divorce. Takes acting and voice lessons, which of course leads to becoming a performer at a gentleman's club in Houston. As a performer at a gentleman's club in Houston, not doing very well because he happens to be a big frame person. who, by her description, and this is a quote, had small assets. So I enlarged my assets in order to improve my working opportunities. Must have worked because she became the most popular dancer in Houston and got a shot at Playboy. The Playboy folks didn't really like her because, again, this is a big frame person who didn't fit within the mold of what Playboy thought they wanted at the time, but Hef took a real shine to her and got her the cover and the centerfold. So now, this person's life, American Dream Part 1, her life is taking off, she's in Playboy, everything's going to be great. But she doesn't want to be Vicki Lynn Hogan because that would embarrass the family back home, so Anna Nicole Smith is born. Shortly after her first Playboy spread, she becomes Anna Nicole Smith, and her acting career takes off. And I will use air quotes on the word career again. Unfortunately, her acting career doesn't take off as much as she had hoped, and soon Anna Nicole is back to performing gentlemen's clubs in Houston. American Dream Part 2. While dancing at one of the gentlemen's clubs in Houston, she meets a man named Mr. Marshall, J. Howard Marshall. J. Howard Marshall happens to be a billionaire, and they fall in love. It's the American dream. Billionaire, exotic dancer, fall in love. How could this be better? Well, they could get married, and they do 2 years later. She at the time is 26, he is 89. It's the American dream. How could this be better? He could die, and he does 13 months later. This is perfect. This is the American dream lived out. She's now 27 years old, and she's going to inherit half of $1.6 billion, except he didn't provide for her in the will. That's a little glitch in the American dream. So how do you reinstate the American dream, get it back on track? You sue. That's the American dream. You sue to get half of the estate. So Anna Nicole Smith sues J. Howard Marshall's estate, and they go down the road of litigation. Unfortunately, he has two sons, one of whom he's disowned, who now teams up with Anna Nicole Smith, and one of whom he liked. And F. Pierce Marshall doesn't like Anna Nicole Smith. Seems stepmom is not on his list of favorite people, so he opposes her attempt to get any money out of the estate. During the course of what becomes 12 years of litigation, Anna Nicole Smith, of all things, gets hit with a sexual harassment judgment by a man from a strip club in Houston. An $850,000 judgment that she can't pay, so she is forced into bankruptcy in the District of Los Angeles. And her bankruptcy judge, who says, property rights, inheritance are property rights. The court can decide those for you. Let me take this issue, and I will rule upon it. And he does. And he awards Anna Nicole Smith $475 million to be paid by Mr. Marshall's estate. That doesn't sit well with son-in-law. Excuse me, stepson. Stepson. Doesn't sit real well with the stepson. First appeal to the Supreme Court. Remanded, same decision, and up we go again. And by the time we get back to the Supreme Court for the second time, Marshall, the son, is dead. Anna Nicole Smith is dead. So we now have Anna Nicole Smith's representative, Howard K. Stern, so it's not to be confused with the real Howard Stern, and Marshall's estate. Hence, Stern versus Marshall, the last Supreme Court decision. And what the Supreme Court held, it was a long way to get to what the Supreme Court held, but just too good a case. The Supreme Court held that because the bankruptcy courts are not Article III courts and do not have full judicial independence under the Constitution, they do not have the ability to enter a final judgment on a state law counterclaim that cannot be resolved in the process of ruling on a creditor's proof of claim. In this case, the Marshalls never filed a proof of claim in Anna Nicole Smith's case, so the court could not have ruled on an objection to proof of claim. Therefore, any state court counterclaims could not be enforced in the bankruptcy court setting. I would like to stand here today and tell you that I have a complete understanding of what that decision means to federal court jurisdiction or bankruptcy court jurisdiction, but I don't believe Judge Nail does, I don't think the 8th Circuit does, because frankly, the courts are still coming down in every different direction on the extent and scope of what Stern versus Marshall means. But you need to be aware that if you are in bankruptcy court and you have state counterclaim issues involved, there may be a limit on what the court can do in relation to those issues. And they may tweak on you a little bit when you're in a Chapter 11 setting and trying to put together a plan. Most recently, a bankruptcy court in the Southern District of Iowa has opined she did not ultimately have to rule because the case went away, that the court would not be able to confirm a plan that tried to rewrite the state's tax authority under a tax sale deed, because that was an issue that was encompassed by Stern versus Marshall. So the plan would be unconfirmable because of the lack of jurisdiction in that aspect. So be aware of that one issue in the bankruptcy setting. And with that, I am probably past my time, and I will thank you very much. I will be around if you want to ask any questions or need anything. Thank you.
Here, Jen. Might need these later on.
Only to see. Thank you.
Thank you. Well, thank you. Let's reconvene. We have Judge Nail this afternoon. We have Christina Schaefer. We have a lot of good material left. So let's reconvene at 3:25. Enjoy some refreshment and fellowship in the meantime.
Justice.